think we will start now. Hello, everyone, and welcome to Season 1, Episode 8 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Nata Ghibradze, and I'm one of the founders of ARBinBRIEF. ARBinBRIEF videos offer a quick resource to consult on issues that arise in international arbitration while showcasing talented arbitrators in an interview format. Over the course of 10 episodes in the first season of ARBinBRIEF, we're moving through the life cycle of an arbitration. Having already discussed topics like case management and pre-hearing conferences and bifurcation of arbitration proceedings, today we're towards the final stages of arbitration, and our speakers will be discussing evaluating witness evidence as arbitrators. Today, I'm very honored to introduce our two very accomplished arbitrators. Our interviewee today is Amani Khalifa, counsel at Freshfields 𝗔𝗥𝗕𝗙𝗥𝗜𝗙, frequently acting as an arbitrator. Our interviewer today is Dr. Rukia Baruti, Secretary General of the African Arbitration Association, and she is an independent arbitrator at the same time. For those who are joining us live, the 15-minute interview today will be followed by a 15-minute Q&A session. Please send any questions you may have via the Q&A function or in the chat box. During the Q&A, any of you who would like to participate will be told to turn the cameras on, and we encourage you to actively participate and directly ask the questions to our speakers today. With this, I leave it over to you, Rukia and Amani.
Thank you very much for that, Nata. Hi, Amani. Amani, as you're aware, there have been concerns raised in fact witness evidence as far as accuracy is concerned. When, in your view, is fact witness evidence used?
Thank you, Rukia. It's lovely to be here with you, and thank you, Nata, for the introduction, and to everybody who's joining live. To answer your question, Rukia, I think from my observations that fact witness evidence is typically used in three ways. The first is to plug evidentiary gaps in the documentary record, and those gaps can either be created by a lack of documents or alternatively by ambiguity in documents. The second is to place documents in their broader practical and commercial context. If you like, this is a little bit the why behind the documents, why they came to exist, and what their relevance and importance is in the context of the commercial transaction. The third and final way that fact witness evidence is typically used in arbitration is to bring the case themes or theory to life, and to provide that human context that, when deployed effectively, can be very persuasive. Arbitrators, as you know, Rukia, are often swayed by the equities of a case, and they can feel a tendency to do justice between the parties, even when they're not formally empowered to decide ex aequo bono.
That makes sense. I suppose another use is probably obtaining evidence from key witnesses who can provide technical explanations in their field. For example, construction professionals, obviously without straying into evidence classified as expert. When would you say fact witness evidence is useful?
Well, unfortunately, that's an altogether different question from when it's used. And in fact, I think that the fact witness evidence that's actually deployed in many cases is maybe not as useful as counsel believe it could be, or believe it is when they deploy it. I think some common problems are fact witnesses who are either too rehearsed and come across as advocating a position that's been carefully articulated by lawyers, instead of simply recalling events that are within their direct knowledge. Alternatively, they can go off topic, contradict their earlier evidence, and be dangerous to the case of the party that's adducing the witness. In many cases, unfortunately, the risks outweigh the benefits, and so unfortunately as well do the costs. That's why I think it's good advice for parties to carefully weigh the risks before they adduce fact witness evidence. In this regard, paragraph 2.2 of the appendix to practice direction 57AC of the CPR rules gives some guidance as to when fact witness evidence shouldn't be used or need not necessarily be used. And that paragraph says that the fact that there is or may be an issue concerning what the disclosed documents mean or show does not, without more, mean that fact witness evidence is required. And I think it's a useful guideline, albeit one that needs to be viewed carefully in the context of the applicable law. So as you know, and as those who are present know, the relevance of extraneous evidence when it comes to issues of contract interpretation is something that varies quite a lot from one applicable law to another. So whilst I think that guideline, it needs to be taken with a healthy degree of a pinch of salt, really, depending on which law is applicable, I think that it is useful as a starting point for counsel seeking to weigh the risks and benefits of when fact witness evidence is really going to advance their case.
It's very good. Of course, as an arbitrator, you want to see factual evidence that can be decisive in a case. But as you've alluded to, having to separate facts from legal arguments or inconsistencies can affect accuracy, which may also compromise the efficient conduct of the arbitration. Do you find that witness evidence is generally accurate?
I think there's a Chinese proverb that is quite appropriate, and that is that the faintest ink is more powerful than the strongest memory. And that's something that I take to heart in how I present cases as counsel. And I think that is a proverb that reflects what we now know about fact witness evidence, which is that honest fact witness recollections can be distorted through the arbitral process. And this is something that has been written about and reported on by the ICC Commission in their report on the accuracy of fact witness testimony. And I think it was also front and center in the appendix to the practice direction that I alluded to. And in fact, that provides that, quite interestingly, I think, for an appendix to the civil procedure rules, it says human memory is vulnerable to being altered by a range of influences such that the individual may or may not be conscious of the alteration. That's in fact the practice, sorry, I believe that's the practice direction. And the ICC Commission report says something similar, which is that science shows that the memory of an honest witness who gives evidence in international arbitration proceedings can easily become distorted and may therefore be less reliable than the witness, counsel, or tribunal expects. So, I mean, I think that's we've strayed maybe into the realm of science a little bit, but I think that the science shows that honest fact witnesses sometimes give inaccurate evidence, and that's something that as arbitrators we need to be very mindful of.
Indeed, it can be challenging, isn't it, to distinguish between inaccurate testimony due to a failure to recall and deliberate efforts to conceal the truth. What do you think can be done to maximize accuracy of fact witness evidence?
So this is helpfully something that is addressed in the practice direction and also by the ICC, maybe somewhat different perspectives. So as far as what counsel can do, the practice direction instructs that counsel should not show the witness documents to refresh their memory if they haven't seen the document before, because this may alter or influence the witness's recollection. I think that's something that intuitively we can think is sensible and is probably accurate. Also, not to put pressure on the witness, to let the witness give their testimony in their own words. And this again goes back to the point of witness testimony perhaps being too rehearsed, and how lawyers can inadvertently undermine the credibility of a witness by overly preparing them. Making the witness statement as concise as possible, limiting it to the facts, and leaving the arguments to the advocates, I think is another good rule. Mm-hmm. In terms of the ICC's approach, it was a little bit more focused on what the tribunal can do, and they had two really good suggestions. The first was for the tribunal to consider requiring a statement of how a witness statement was prepared, which I think will maybe provide some discipline in terms of the excessive involvement of counsel in preparing witnesses. And the second thing that they suggest could be useful is the taking of evidence at the outset. So it remains to be seen really whether this sort of becomes a best practice or a common practice, and how this is adopted by tribunals in commercial cases.
Indeed. I mean, naturally, the usefulness of some suggestions will depend on the circumstances of the case. For instance, I can see how showing documents can taint a witness's memory in one instance, but in another, where exact recollection is not necessary, they may be beneficial in providing context, for instance. Earlier, you alluded to rehearsed or coached witness testimony, which is very interesting. Maybe you can share your views on what to do as a tribunal to avoid fully rehearsed testimony and make it useful for the tribunal.
I think it's a very difficult one to manage, because as an arbitrator, as you know, you're always very conscious that you need to allow the parties a full opportunity to present their case, and any sort of curtailment of the right to present witness testimony can pose problems at the annulment stage, depending on the applicable laws and the seat of the arbitration. So I think tribunals are generally hesitant to say upfront that a witness testimony is not useful. I think that tribunals can do more to guide parties in terms of what the issues are. I personally find that drawing up terms of reference is a useful tool where you have perhaps underdeveloped claims in the request and the answer, or inexperienced counsel, and referring back to those and what really is at issue in the case in terms of the relief sought by the parties can be a good disciplining tool as a reminder. But I think a lot of tribunals would fall short of saying, you can't, that witness can't testify, it can only testify about these topics, because of the due process implications of doing that and going that extra step.
Of course, that makes absolute sense. I mean, fully rehearsed testimony is acceptable in some laws, but not all laws. But in cases where it is, you're right, I'd also be inclined to suggest a discussion maybe at the outset with the parties to make it a more focused approach to witness testimony. On the tribunal's role, the Delos rules provide in Article 12.4 that the tribunal shall take an active role in the resolution of legal and factual issues on the basis of the parties' submissions. Is the amount and type of witness evidence a matter that can be left entirely to the parties, or should the tribunal give guidance or directions on this point?
It's really interesting that you should say that. I think the spirit of the Delos rules is to invite the arbitrator to take greater control of the process in the interests of efficiency. And I think that's a useful overarching principle that the tribunal should bear in mind when deciding cases under those rules. However, I think the sort of the yardstick of an active role is something that could be interpreted differently by different arbitrators and different people. I think it's a question of temperament, but it's again also a question of the applicable law and the constraints that you have in terms of the laws of the seat and ensuring that both parties are given a full opportunity to present their respective cases. And of course, there may be an inherent imbalance in the parties' positions where one party, the case put forward by one party may be more reliant on fact witness evidence. And so you've got to be careful that you're treating the parties fairly, even where there is that imbalance. So I think, as I said, reminding the parties of the issues that the tribunal is truly interested in, the decision tree, if you will, is a good thing, so to focus their efforts. But ultimately, I think the onus is on counsel to kind of give that discipline in ensuring that the costs are not unduly driven up because of the constraints that the tribunal has, obviously, until it's heard the evidence as to the usefulness or otherwise of that evidence. And same goes for the decision to cross-examine a witness. Often I find that counsel will cross-examine a witness, even knowing that the witness's testimony is marginally relevant or completely irrelevant to the issues, just as a way of undermining that witness's credibility. And again, I think, there needs to be a focus on what the parties' respective cases is and what exactly is the relief they're requesting from the tribunal in terms of the way the case is presented. And all too often, I think costs are driven up because that focus is lost a little bit in the kind of the rough and tumble of the case.
Of course. And in cases where due process is adversely impacted and there's no express authority for the tribunal to act, it can always exercise its implied or inherent powers to limit parties' ability to have carte blanche, so to speak, on witness evidence. It would be remiss of me not to refer to virtual hearings because of the times that we're currently living in. Apart from the issue of potentially being easier to be coached as a witness, is the virtual setting in itself making it easier for witnesses to lie, do you think? Or does the virtual setting provide a more relaxed environment?
I would say that in many cases, perhaps in most all commercial cases, it's equally difficult to lie in the virtual and in-person settings, and the addition of the virtual setting doesn't make the testimony inherently less accurate. However, I think I'm speaking to colleagues of mine that sit in sports cases where there's a sanctions context, and you have individual witnesses with a very, very strong incentive to lie, can exploit the virtual setting. So I know of a case where there was an issue with a witness leaving their mobile phone on while they were giving evidence, so that another witness who was giving evidence later on in the proceedings was able to hear the testimony in circumstances where that wasn't allowed by the tribunal. And I think there've been really interesting attempts in terms of protocols to try and control the physical environment that a witness is giving testimony in a virtual setting, and those are really useful. But if a witness is hell-bent and determined on circumventing those, then I suppose they would find it marginally easier to do that than in a situation where everybody is sitting in a room together. And obviously you could sort of deploy someone to go and be physically present, but there's a cost associated with that, and often in that situation one wonders then why not get together in a room. So you've got to strike a balance between the convenience and cost efficiency of the virtual setting and the kind of the ability to control the environment that an in-person setting affords.
Absolutely. All those are very good points that you make, Amani. I also think being able to observe a witness's demeanor is very critical to the ability of a tribunal to assess evidence properly. Well, thank you so very much for your time, Amani. That was very informative indeed.
Thank you very much, Rukia.
Thank you both, Amani and Rukia, for this very incredible discussion on the topic of witness evidence and evaluating from arbitrators' perspective. Before we come to an end, I would like to, of course, thank our partner organizations, Delos, Mundi, and ARBpledge for their invaluable support. Delos Dispute Resolution is an independent arbitrator institution established in 2014. Mundi provides arbitrator research tools for lawyers, including a directory of more than 5,000 profiles with arbitrator analytics. The ARBpledge, on the other hand, establishes concrete and actionable steps to increase the number of women appointed as arbitrators, with ultimate goal of full parity. We're also very happy that season 1 of ARBinBRIEF is supported by ArbitralWomen, Careers in Arbitration, and the Rising Arbitrators Initiative. We thank them all. And of course, we thank you all who are joining us live today. To see future ARBinBRIEF videos, please follow us on LinkedIn, like and subscribe to our YouTube channel. And of course, we would like to hear from you and get your feedback. And you can register also for our next episode, episode 9, on www.arbinbrief.com.